welcome to the channel Beginner's Paradise. So today's topic of discussion is schedules to the Constitution of India. There are 12 schedules. 8 schedules were there in original constitutions and 4 were added via subsequent amendments. While all the schedules are important from exam point of view, but some of them are relatively more complex and hence would require additional simplification. Let's quickly understand the importance of schedules. So first thing first, it aids the comprehension and readability of the articles and helps interpret the legislation more effectively, which means it strengthens the aspect of judicial review since it helps in interpretation of legislation. So first importance is it aids the comprehension and readability. The second importance is the schedule makes the whole part as very concise. Our constitution is very lengthy. So schedules in a nutshell bring everything of our constitution within a very concise format. So it contains the ethos of our constitution. It'll be right to say that schedules contains the ethos of our constitution. A third importance of schedules are they are easy to understand language. Constitution of India has always been criticized for having a very tricky language, and until unless you are a very well educated lawyer, it is difficult for a layman to understand the language used. So schedules here also comes handy because the language used is very understandable and the approach is very layman friendly, and that's also where the schedules are very important as it spreads the reachability of the constitution and its ethos to the layman. So now let's go through all the schedules. First, Schedule 1. So Schedule 1 contains the name of the states and union territories. So what all states are in India and union territories are Indian, all those names are contained in Schedule 1. Suppose there is a new state added and bifurcated, it will be amendment to Schedule 1 and insertion of that state's name will be in Schedule 1. And also it defines the territorial jurisdiction of states. So which state's territory extends to which geographical boundary is also contained in Schedule 1. Then Schedule 2 of the Constitution. The provisions related to allowances, privileges, emoluments of President of India, Governor of States, Speaker of Lok Sabha and Chairman of Rajya Sabha, Supreme Court judges, High Court judges and Controller Auditor General and other such posts. So all the allowances, privileges and emoluments of all these important personalities, important institutions are contained in Schedule 2. So it aids the transparency aspect of all these big institutions and people holding these posts. So Schedule 2 is again allowances, privileges and emoluments of all these important institutions and people holding those posts. So it aids the transparency aspects of our Constitution. Now Schedule 3 of the Constitution. It contains the forms of oath and affirmation. So every Union Minister, Member of Parliament, Judges of Supreme Court, CAG and other such posts have different oaths and affirmations. Alright, the President has different oath, Member of Parliament has different oath and Supreme Court judge has different oath. So all those different oaths and affirmations are contained in Schedule 3. So every time there is an oath and affirmation, there is clearly written rule as to which oath and affirmation will be taken by which individual holding a particular post. That is included in Schedule 3. Now Schedule 4 is regarding allocation of seats in Rajya Sabha. So there are allocation of seats to different states and different union territories according to the population, so that everybody is represented in the upper house, that is the Rajya Sabha. That all those allocation of seats in Rajya Sabha are contained in Schedule 4. And articles related to this schedule are Article 4 and Article 8C. So again, Schedule 4 is allocation of seats in the Rajya Sabha to the states and union territories. As discussed above, some of the schedules have larger impact and are relatively more important from exam point of view and thus require some detailing. So Schedule 5, provisions relating to administration and control of schedule area and schedule tribes. So all those areas and tribes living in those areas, their administration and control, and any article or provisions in our constitution relating to administration in schedule area and schedule tribe are included within Schedule 5. So does it cover all schedule and tribal areas? The answer is no. Not all the tribal habitations are covered under Schedule 5 or Schedule 6 for that matter. Fifth schedule applies to an overwhelming majority of India's tribes in 10 states. Moreover, President under Article 244, Clause 1 of the Constitution may declare any area as schedule area from time to time. Now, executive power of the union government extends to Schedule 5 areas. So we will see how the union's executive authority does not extend to administration and control of schedule areas and schedule tribes under Schedule 6. Schedule 6 excludes unions' executive power from their areas, while in Schedule 5, unions or centers' executive authority extends. So now Schedule 6. Schedule 6 and Schedule 5 are roughly the same, apart from that Schedule 6 applies to 4 states: Assam, Meghalaya, Tripura and Mizoram, right? Only these 4 states, the administration of tribal areas are considered under Schedule 6. Now why we had to create a separate schedule for this is a matter of concern and debate, but the major difference between Schedule 5 and Schedule 6 is, as we have already discussed before, center's authority and rights do not extend, executive authority that is, do not extend to Schedule 6 areas. 6th schedule gives tribal communities considerable autonomy. The state of Assam, Tripura, Mizoram and Meghalaya are given considerable autonomy. In fact, there is a autonomous district council set up in these 4 states, and extensive power has been given to governor to increase and decrease the area or change the name of those autonomous districts. So the devolution of administration of those areas is done at a more advanced level when compared to Schedule 5 areas. All right, so there are autonomous district councils that we are talking about when it comes to Schedule 6 areas. Union's executive authority does not extend to Schedule 6 areas. It's strictly limited to states' authority. So in Schedule 6 areas, only states' executive authority extends. Now, it seeks to safeguard the rights of the tribal population through the formation of autonomous district council. So which schedule provides for autonomous district council? It is Schedule 6. Only 4 states are covered under Schedule 6 again: Assam, Tripura, Mizoram and Meghalaya, states that border China and Myanmar. Alright, autonomous district councils are bodies representing a district to which the constitution has given varying degrees of autonomy within the state legislature. Alright, the constitution has given varying degree of autonomy to these autonomous district councils, which means that Panchayati Raj system or Tier 3 system of our constitution does not extend to these areas. These areas are given autonomy and freedom to run the administration the way they have been doing for ages. All right, so that's the autonomy that is given to them, and it is done through autonomous district councils. Now, autonomous district councils are empowered with civil and judicial powers also, and village courts within their jurisdiction has the power to trial the cases involving any cases involving the tribes can be heard and tried in the autonomous district council. So autonomous district councils also work as civil and judicial courts. All right. Governor can specify the jurisdictions of high court from each of these areas. So uh, even the high court's jurisdiction is not entirely uh, absolute in those areas. The governor has the right and the authority to specify to which extent high court jurisdiction extends. So you see how these autonomous district councils are made very powerful to protect the rights and way of living of the tribal communities in all those 4 states, that even the high court jurisdiction is not absolute. Moreover, the governor is given extensive powers to name and to select how these areas are going to impact which tribes and what is the extent of autonomous district council. All these powers are given to governors. So this is about schedule 6 areas. Again, schedule 6 area covers 4 states: Assam, Meghalaya, Tripura and Mizoram. Now, schedule 7. So, it is about division of power between center and state. So, whether center or state has the right to legislate on a particular subject, and what are their exclusive areas where they can legislate and make policies, or what are the areas where both can make policies. These are the entries that are within schedule 7. So union list, that is the union's exclusive right to legislate, there are 100 subject covered in union list. State list, where the state's exclusive authority lies on as far as legislation is concerned, it is considered, it is a part of states lists, and there are currently 61 subject in states list. And then there are concurrent list, which has 52 subjects. Concurrent lists, all the subjects, that are 52 subjects in concurrent list, both center and state can legislate. However, there is a catch: center's residuary power, which means that if center has legislated on the same subject, it overrides the state's legislation on the similar subject. So center here has an upper hand as far as concurrent list is concerned, but the right of legislation also extends to the states and centers equally. However, when it comes to state list, states authority to legislate is absolute, and so is union's authority when it comes to union list. Again, there are 100 subject in union list, 61 subject in states list, and 52 subjects in concurrent list. Now, this schedule 7 can be said to enable the federal character of our nation, which because it clearly demarcates the legislative power of union and states. And in case of conflict as to who is empowered to legislate on a particular subject, a reference can be made to 7th schedule of Indian Constitution. Schedule 8, languages recognized by the Constitution, is so all those official languages that is recognized by the Constitution is covered under Schedule 8. Originally it had only 14 languages, but presently there are 22 languages, the most recent additions being Bodo, Dongri, Maithili and Santhali. So you would see a lot of local languages, there are activists who want them to become a official language. So is there a benefit related to being called an official language of the Republic of India? So yes, there is a benefit. Inclusion in the list would simply mean that Government of India is now under an obligation to take measures for the development of these languages such that they become effective means of communicating modern knowledge. So it means financial investments and other such cultural programs will be created and facilitated so that that particular language growth is now a government's obligation. They'll have to do it. So that is the benefit of being recognized as official language of the Republic of India. So Schedule 9 then, acts and regulations related to land reforms, abolition of Zamindari system. Now, this schedule was added by First Amendment to protect the laws included in it from judicial scrutiny on the grounds of violation of fundamental rights. So the ninth schedule contains a list of central and state laws which cannot be challenged in courts. I'll give you an example. Our constitution provides a reservation, but that is valid only up to 50% of the quota. All right, so maximum reservation that you can provide in terms of admission into institutions or jobs is 50%. Tamil Nadu government gave a reservation of up to 68%, which was violative of the constitutional provision. But since it was added to the ninth schedule of the constitution, it has never been questioned. So that's the whole idea of Schedule 9, where it saves the articles or the provisions from judicial review, judicial scrutiny. But in recent years, Apex Court, that is the Supreme Court, has said that even articles and legislation included in Schedule 9 are now open to judicial scrutiny and judicial review if they seem to violate fundamental rights or the basic structures doctrine. Schedule number 10. It is basically disqualification on the grounds of defection. So there is a provision to disqualify people if you defect from a particular political party after you have been elected. All right, so that provision is contained in Schedule 10. So Schedule 10 again is disqualification on the grounds of defection. It was added by 52nd Amendment 1985 and is also known as anti-defection law. So it was a phrase that became popular in Indian politics, like Ayaram Gayaram, after a Haryana MLA, Gaya Lal, changed his party thrice within the same day in 1967. The anti-defection law seeks to prevent such political defections which may be due to reward of office or other similar considerations. It lays down the process by which legislator may be disqualified on grounds of defection by the president officer of a legislature based on a petition by any other member of the house. So there are exceptions to this, like most of these laws do not apply to independent members, but we will discuss that in a separate video where we'll do this anti-defection law and its implications on the Indian political system. But for the timing, Schedule 10 is anti-defection law or disqualification on the grounds of defection. Now Schedule 11 and 12 will be done together because they're not different, but only Schedule 11 applies to rural areas and Schedule 12 applies to urban area. Their impact, their importance, their intention is very similar. Although Schedule 11, in my opinion, is way more important because it extends to all those remote areas where democracy was not reaching back then and has not reached. Schedule 11 made sure that it reaches every nook and corner of our country. So Schedule 11 is about powers, authorities and responsibilities of panchayats. It has 29 matters. This schedule was added by 73rd Amendment Act of 1992. So in many a times you'd see questions where they'll directly say consider these statements regarding 73rd Amendment. So you're supposed to know that 73rd Amendment or 11th schedule is about Panchayati Raj system. So and 12th schedule again is about municipalities. So rural and urban. All right, we are covering both. So Schedule 11 has 29 matters and the provisions of the articles are covered within this provision is Article 243 and Article 243 Clause O. Now this amendment implements the Article 40 of Directive Principles of State Policy, which says that state shall take step to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. So basically, these provisions enable and extend the units of self-government at the lowest rung of our society. Now, furthermore, they have upgraded from non-justifiable to justifiable part of the constitution. So DPSP, that is Directive Principles of State Policy, are non-justifiable. I've already discussed about it if you see previous videos, but again we'll do it. Justifiable means you can go to a court to enforce those particular provisions if it is justifiable. But Directive Principle of State Policies are not justifiable. But now, because of this Schedule 11 and 12, the fulfillment of Article 40 of DPSP, now they have become justifiable. So you can go to court to enforce your rights to be elected in Panchayati Raj. Alright. And they are covered under Part 11 of the Constitution. Alright. Sorry, Part 9 of the Constitution, I beg your pardon. Part 9 of the Constitution. However, states have been given enough freedom to take their geographical, politico-administrative and other conditions into account while adopting the Panchayati Raj system. So adopting Panchayati Raj system is mandatory, but their formation and their area and their width and the geographical reach can be altered by different states differently. Alright. Also, it adds third tier to our democratic setup. India is first such country to add third tier to the constitution and third tier to the idea of self-government. There is a provision of reservation for seats for SCs, STs and women's. So it also seeks to bring equality into political equality in those areas. Alright. It also requires the state to appoint the Finance Commission every 5 years. It means it's also an agent of financial devolution in the Panchayati Raj system. In the Panchayats, financial devolution also takes place, and it is mandatory that state appoint Finance Commission every 5 years for financial devolution to Panchayati Raj. So again, then let's quickly go through Schedule 12. It is powers, authorities and responsibilities of municipalities. It has 18 matters within its ambit. Schedule 12 applies to municipalities and Schedule 11 applies to panchayats. This schedule was added by 74th Amendment Act of 1992. So if question is about 73rd Amendment Act, you are supposed to write about Panchayati Raj, and if the question is about 74th Amendment Act, you're supposed to take it as a question on Schedule 12 or municipality. Alright, so that's it for the class. Thank you very much. If you like the content, for more such content, please do consider liking and subscribing to the channel Beginner's Paradise. Have a great day all of you.